attorney here. Today we will hear a presentation by Bergia Hensley. She's an assistant juvenile defender in the central part of our state. Bergia practiced in Western North Carolina for a number of years, I think about 10 years, before she moved out to the Raleigh area and now works in Wake County and is an awesome juvenile defender for that region and for the state. Eric Zagrait is the state juvenile defender. He has been with the office since 2005. He was an assistant public defender in Guilford County before that, has worked in this field for most of his career and is a tireless advocate for youth. They are going to give us a great rundown of what to expect when you enter juvenile delinquency court and give us a kind of a refresher on the court system. So I will turn it over to them.
Thank you. So that was our introduction. That was fantastic. Let's see if we can get this technology to cooperate. All right, boss, I have to take the control back from you, and then I'll give it back to you later. But I think we figured it out, so. All right, so what we want to go over with you guys is the delinquency courtroom. This is, we hope, is going to be applicable not only to the attorneys that are just starting to do this work, but also to those of you that have been doing defense work generally and are maybe either interested in getting into the delinquency courtroom, or for those of you that are joining us, especially in regards to the first degree murder roster and doing that work, getting a better idea of what is involved in the juvenile courtroom before a case is transferred. So today we're going to break it up into something like this. We'll talk about the purpose of delinquency court, who is a juvenile and their rights. We'll talk about the scope of representing them, and that follows them through transfer if that's what happens with the case. We'll talk about the terminology and the special language that we use and why we do that. And then we will spend a good bit of time talking about jurisdiction of delinquency court, the proceedings, what steps are involved, how each of those steps go. And then we want to leave you guys with some resources and data to look back on. As we go through all of this information, whenever there's a statute number involved, we will reference that on the slide, and we'll make sure all this stuff is available to you so that when you go back, you can know exactly what part of the code to look at. So like I said, we'll start with the purpose of juvenile court, talk about who a juvenile is and their rights. The purpose of juvenile court, beautifully enough, is codified in statute. We love that because judges really like to lean on the statute. It's black and white. And there's 3 different places that refer to the purpose of having a separate delinquency court. 7B 1500, so Chapter 7B of Chapter 7 is is the delinquency code. So that's where all of our statutes are going to be. And 7B 1500 at the beginning of the delinquency part of that code is the purpose statute. So as you can see, it's black and white: to protect the public, to deter delinquency through swift and effective dispositions, including accountability for the child's actions, and including rehabilitative services as a core purpose of having a separate court for children. Intake, screening, and resources, and fairness, equity, protection, and speed. And you can see already in this very first statute, just talking about why we have a separate court, there are 2 different references to, there's swift and effective dispositions, and then there's a reference to speed. So there is a whole body of science about how the child's brain works. And we know that through the science or even just real life experience, children develop and grow in a manner which, if we don't respond quickly, then it becomes a moot issue, so to speak. So there's a focus on handling things as quickly as is possible and is appropriate. We have 7B 2412, which is the legal effect of adjudication of delinquency. So we'll get to the terminology here in a second. But what I wanted to highlight here is that it is codified in our statute that juvenile delinquency cases are not convictions of criminal offenses. We're not convicting children of crimes. We're adjudicating them. That's part of why we use separate language. It is not a conviction. It is not a criminal offense. And then finally, in 7B 2500, this is the disposition in the section of the statute of the code, and so that's the adult equivalent of sentencing, essentially. And it says the purpose of dispositions in juvenile actions is to design an appropriate plan to meet the needs of the juvenile. So it's written right into the code that we're focusing on the child and we're focusing on what that child needs. And we're not talking about just punishment or, we're working with the child and what that child needs. So with that purpose in mind, let's talk about, officially, who is a juvenile. And I put juvenile in quotation marks, and you'll hear me say either juvenile or child or youth. When I'm speaking about the child, I say child or youth because I don't like the negative connotations of the word juvenile. That's a thing. In the code, they're, in the definition section, that's what they're going to be referred to as. So if it's delinquency court or juvenile as it's used in the statute, I'm going to use that word. But otherwise, I'm referring to these small humans as children or youth or something to that effect. So delinquent juvenile. So these children that come into the delinquency courtroom, and this is in 7B 1501, there are three kind of sets of kids that are going to be in the jurisdiction of juvenile delinquency court. So if they're at least 10 years old, but less than having not turned 18 yet, any offense, misdemeanor or felony level other than motor vehicle offenses for the 16 and 17-year-olds, it puts them in the jurisdiction of delinquency court. If they're between 8 and 10 years old, then the really serious stuff, class A through G felonies. And then if they are at least 8 years old, but less than 10 years old, so between 8 and 10, and they have any prior delinquency adjudications. That's eventually going to phase out, unless, of course, they have something very serious. But generally speaking, these are the children that can fall in the jurisdiction of delinquency court. You'll hear juvenile in other ways. So there's something called a vulnerable juvenile. It's worth mentioning. That is a child between the ages of 6 and 10 that is not otherwise one of these delinquent juveniles on the left-hand side. Those do not come into court. We have at least raised the minimum age to that degree, where we're not hauling a 6-year-old into court for picking a sunflower and causing injury to real property, injury to personal property. We're still working on it, but for now, that's where we are. You'll also note that in 7B in the code, subsection 1501 defines undisciplined juvenile. So that is a child that is at least 10 years old, has not yet turned 18, and they are considered beyond the disciplinary control of the parent or guardian. So they're misbehaving. They're not going to school, but they're not rising to the level of committing, what the adult code codifies as criminal offenses. Those we're not going to talk about either. Those are not the children that, at least in North Carolina, unfortunately at this point, are entitled to an attorney to represent them. But keep in mind that they are also classified in that code. And then if you go to the beginning of Chapter 7B, you have abused, neglect, or dependent juveniles. Those are the children, they are not in trouble for something. It's alleged that their parents did something to the child. So they are referred to as juveniles. Their courtroom, the A&D courtroom, is juvenile court, but they are not the delinquent children that we're talking about. Okay, so now that we know who they are, let's talk about their rights. This is sort of the foundation of why we have a courtroom in which we have the child and then we have the child's attorney. Right? In re Galt from 1967 is the seminal case that established that children have due process rights. They have the right to counsel. They have the right to notice of charges constitutionally, right? They have the right to confrontation and cross-examination. They have a privilege against self-incrimination that gets real fun in practice. And then they also have a right to appellate review. In addition to what's established in the case law, we've also codified some of these rights as well. So they've got the constitutional rights they also have statutory rights. So in this case, we're looking at 7B 2000, and that spells out that any delinquent child, again, we don't like the word, but in terms of how it's used in the statute and the definitions, any child in delinquency court charged with a delinquent act has a right to counsel. Also, any child that is charged with contempt of court in undisciplined proceedings also has a right to counsel. And in the statute, it does say that these children are conclusively presumed to be indigent. In practice, the delinquency course, there's, I haven't seen anybody have an issue with that. Where it gets interesting is when a case is transferred to adult court, and now we're in the adult statute, and how do those judges treat that? So keep this in mind. 7B 2000 does statutorily define these children in a way that are conclusively presumed to be indigent. Okay, and then 7B 2405 also has their rights spelled out statutorily. So we have, and these rights are specifically connected to the adjudicatory hearing. Kind of keep that in mind. I could see maybe a prosecutor trying to throw a hissy fit if you try to invoke them ahead of time, but I haven't seen that happen before. But know that this is here and in writing, black and white. The child has a right to written notice of their charges. They have the right to counsel, the right to confront and cross-examine. It's in there in 2405 again. They have the privilege against self-incrimination, and there's a right of discovery. So remember, we're in district court with delinquency court. Unless it transfers, the entirety of the case is handled in district court. And we have not only referenced in 2405, but a separate discovery statute altogether that gives a statutory right to discovery to these children while in district court. And then the 2405 also states that children are afforded all of the rights that are afforded to adult offenders, except for the right to bail, the right of self-representation, and there's no right to trial by jury in district court. Okay, we're in court. We understand who our client is and what their rights are. So let's take a look at what our job is. What is our scope of representation? What are we doing in that courtroom? We are representing that child. So I want to talk to you kind of what that means in regards to our role as counsel, our duties, and then touch a little bit on diminished capacity as well. So there are two types of advocacy that attorneys can be assigned to do, or stakeholders can have: expressed interest and best interest. In the delinquency courtroom, the judge, the parents, the court counselor, the prosecutor, maybe the service providers, even possibly a school, are telling the judge what is in the best interest of this child. We, as the defense attorney, are not best interest advocates. We are expressed interest advocates, and we are telling the judge what this child wants. We are acting at the direction of the child, of course, assuming they understand what's going on and are able to give us that direction. And our job is to express to the judge those things that the child wants and take direction from the child as to how they want to handle their case. Everybody else in the courtroom will tell the judge what the child needs. You are the only person in that courtroom that can tell the judge what the child wants. So when we're talking about working with your client, that inevitably implicates communication and your duty to communicate with your child and confidentiality. So we do have the same ethical duties with our children in the courtroom as we would with adults, except there's actually a higher standard of confidentiality. So we won't dive into all the details of it, but the juvenile courtroom does provide greater protections for confidentiality. And so as the child's attorney, we must uphold that higher standard. And it gets very interesting when the fact of the matter is the parent or the guardian is going to be involved in this process. They know what the charge is, and they are probably going to butt their nose in and try to be involved. That they're the parent. That's often what they do. And sometimes that's helpful, sometimes it's not. But remember, that parent or that guardian is not the client. Yes, they are a stakeholder, but you are taking your direction from your client. Your instructions come from your client. So regardless of what the parent says, and in fact, your child, the child is going to be the one to tell you, yes, you can talk to this person, or no, don't even bother talking to them. And finally, with all of this, it is your duty to communicate in a way with your client in a way that they understand. So um, I'm going to come back to that here in a second. The question becomes, when you're trying to explain something to your client, are they understanding what you're trying to explain to them? So again, part of your job is to take the time to explain in a way that your child is going to understand. We're not going to use the big terms. We're not going to use 15 syllable words. We're going to break it down and speak to the child at their level in a way that they understand. So proper language. Consider, are you going to talk to them on the phone? Are you going to text them? Are you going to discuss this in person? Different forms of communication have different levels of effectiveness, and we are talking about a different generation. Consider their maturity, their intellect, and even their background, their cultural background. That can affect how effective your communication with this child is. And finally, the question you're asking when you're talking about whether or not they have the diminished capacity that leads to them, a capacity to proceed conversation or otherwise their ability to give you instructions. You're asking, can this child process this information and then take it and express what they desire based on the information that's been presented to them? So that's the ultimate question that you're asking. And to do that, remember, we're going to use the proper language. I was trying to segue, but there you go, boss.
All right. Well, hopefully technology will not fail us here. Any questions before I start? All right. So as Berger said, we all know that as lawyers, our greatest tools are our words. Well, coming in at delinquency court, it gets a little complicated. I've known some lawyers to run from this courtroom just by standing in there for 5 minutes because there was like, can somebody speak like English to me? So let me see. I'm hovering, Berger. I'm hovering.
Click one time, boss. There
There
it
we
is.
go. All right. So there's an entirely different lexicon in juvenile court for every adult criminal term, including the most basic ones. So as you heard Berger discuss, the official term is juvenile, but sometimes we refer to them as youth or children, but they're not defendants. And instead of a crime, it's a delinquent act. Sometimes you see the language, a crime. It would be a crime if committed by an adult, but don't be confused. It is a crime. It's just labeled something different. Whoops, I clicked too fast. Arrest is custody. So even some of us talk about, well, was your client arrested or not? But really, were they taken into custody and placed into detention, which we'll talk about in a little while. There are no warrants, but I'm sorry, I keep doing this twice. There are no warrants, but there are petitions. If you've been in juvenile court, um, those AOC forms. I don't know how much we talk too much about forms here, but generally, for most of the actions we will discuss, there should be an AOC form. All right, just clicking once. So instead of a trial, we call it a hearing or adjudicatory hearing. But it's the same thing. And as Berger mentioned earlier, many of the same rights apply. And not a conviction. So this is really the crux of our discussion here with terminology. And the reason why we use different terms and we don't say conviction is the whole idea behind juvenile court, that it's the separate process. The idea is that it gives young people another chance at not being incarcerated, participating in society. Conviction really is the core term here, and you'll see whether it's applying for a job or how it's described in the code. Adjudications are not convictions. That's sort of the core term. And with that, we have, instead of you plead guilty, you admit responsibility. And at that point, you are adjudicated. This is another core term that we'll talk about in a fair amount of detail. So generally, in adult criminal court, you are convicted of an act, you look at your prior record, and you go down a chart, you figure out, are you in the community? Are you in an intermediate sanction with some time and some community resources? Are you just locked up? In juvenile court, it's more complex. And so we refer to it as a disposition. Sometimes we refer to it as big D disposition, not just small d, because sometimes in criminal court you use small d disposition, but this is big D. Probation officer and court counselor. Couple things with this. Probation officers basically have, somebody correct me, one duty. They work with people after they have been convicted and sentenced. But court counselors serve all kinds of roles that we'll get to in a minute. But one of the roles they serve is as a probation officer. So sometimes that's seen as synonymous. Okay, so as you may imagine, and I know there's been a lot more attention paid to this once Raise the Age was passed and implemented, youth under the age of 18 are in juvenile detention centers, not jails. And one of the core takeaways from this is that there's now 13 detention centers across the state. There's 12 or 13. There's a jail in every county, basically. That's a huge difference. They look and feel like jails, but there are fewer. And the laws surrounding how you get in short-term incarceration and how you get out of it can be complicated. All right. And long-term incarceration, of course, is prison. We call these youth development centers. That's an interesting term. We usually refer to them as YDC. So sometimes if you hear YDC, that's what we're talking about. Okay. As mentioned, there are a number of different folks you are going to be interacting with in juvenile court. First is the judge, largely district court judges. Occasionally, you might, for example, appeal transfer and go in front of superior court judge, but largely we're talking about the district court bench. The defender, that's you, the juvenile defender. The prosecutor. Okay, so depending on where you practice, sometimes there are designated assistant district attorneys and sometimes there's not. It's something to find out. They do have now a full-time juvenile resource prosecutor, sort of the function that we serve to you all as defense counsel, but the prosecutors, are basically what you're used to. Your youth client, the parents or guardians of your client, and this can also be a little complex. Maybe they're in the custody of Department of Social Services, maybe there's foster parents, maybe they're living in out-of-home placement, but there could be more than one person or persons you need to talk to get background about your client and figure out how to interact with these folks. Law enforcement, of course, is no different. There's no special juvenile police or anything like that. It's all law enforcement. Sometimes there's a juvenile unit in some jurisdictions if they're large enough, but they're all law enforcement. Generally, city police or sheriffs. All right, I mentioned the court counselor. So they serve a number of roles. They are the intake service. So when a petition is filed to determine whether or not a case should come to court, they get to make that decision. They provide recommendations about whether or not the youth should be released. And upon adjudication, what disposition should look like. Then they are responsible for the sort of traditional probation officer role of keeping up with their clients on their caseload. And there's even some other bits and pieces that they do, but those are the main parts. Service providers. Again, this could be any number of individuals, including, like I said, foster parents, DSS, group home placement, mental health, educational services, child welfare, all of that. All right. Raise the age was great, except now we've got all these different combinations and permutations of who's in court and where they go. I am not going to go over this entire chart because that would take the next half hour, but this is something to really understand. The whole reason we have a juvenile court is due to their age. So there are all kinds of um, connections with your client's age, even outside of jurisdiction, but these are the basics to know. And the folks we're talking about largely are in this area. As Berja mentioned, not many 8 or 9-year-olds. But if you look over here, you can still be up to 21 in the juvenile justice system. So you can be as young as 8 or 9 and as old as 20, going on 21. That's a wide range of people. All right, so now we're going to talk about proceedings. Pre-adjudication, before trial, basically, adjudication, the determination of your client's responsibility, disposition, sort of like sentencing, and post-disposition, what happens after disposition is entered. I'm still going, right, Berja?
Yep.
Because now my numbers are up. That's okay. All right, so law enforcement intake and diversion. Petition and secure custody. First appearance, probable cause transfer. Berja did a nice job of sort of explaining who is involved in these different parts of the proceedings, but these are the main pieces. We're going to talk about one at a time. And let us start with pre-adjudication, intake, and diversion. Okay. I don't know that we particularly have a law enforcement slide. Am I missing that?
I don't think we have a specific one, no.
The only thing I would say about law enforcement, like I mentioned before, is that they largely operate like they do in adult criminal court, but there are specific rules with things like secure custody and others where they do have to interact with the parents. So just be aware of that. You know, we're doing sort of the 30,000 foot version, so I'm not going to go into a lot of details. But if you have a question about law enforcement's interaction with your client, feel free to contact us and we'll be glad to talk to you. Okay, as I mentioned before, court counselors control the decision as to whether, more or less, as to whether or not a case comes to court. This is very different than an adult criminal court. You go to a magistrate, crime occurs in front of the law enforcement officer, civilian makes a complaint. This is a little more, I want to say focused, maybe that's I'm giving it too much credit, but if a member of the public, law enforcement, has a question or an issue about should they file it, how do they file it, they go to juvenile justice intake and they file the initial paperwork that says this person has been charged with something. Well, after the allegations are made, juvenile justice intake meets with the youth and the family and then determines what to do next, because you don't just have to go to court or not go to court. You can just close it with no action. You can divert it. Now, there's a lot of aspects to this. I'm not going to go into much detail, but this can be anything from like a specific resource like teen court to being under a contract, sort of like a continuance before you even get into court. And a lot of things in between. There's a lot of, I think, leeway here. And then lastly, of course, juvenile justice can file the petition with the clerk's office as the new sets of charges. So like I mentioned, they have the power to divert, and this is described in statute. As I mentioned, they can be just referred to community resources, don't have to go through the system at all. I also mentioned the diversion contract. I was already ahead of myself, wasn't I? And these are just some details with that. This is not, it's not like a binding agreement. It's just an agreement to pursue these actions that DJJ is recommending. But of course, if it's incomplete or simply not done, the youth can go to court.
And boss, I think one of the best things to remember about the diversion contracts as part of the intake process, the attorney can potentially have a positive impact if the court counselor is trying to get a hold of, for example, this family that on something that they would normally divert, but they can't get a hold of them or something to that effect. And they don't really have a choice but to file a petition. But if you are in contact with this family, you can say, well, let me go to the intake with you. I think we can have this diverted and potentially influence the case to not even be in court right from that point.
Yes, but what has to happen first?
Trick question.
Yeah, that's so Berge is correct, but that's only if somehow you had been previously appointed. You actually don't have access to counsel until the case is filed in court. But Berge is right. We get questions from attorneys who've represented the kid in the past or from retained attorneys. Can I go to intake and help? Yes. Now, another main takeaway from, this presentation is that you need to know your local system before you do anything. We highly encourage you to meet with the chief court counselor, to talk to the defenders about how it works, because some offices will not look kindly upon that. And they'll say, well, you're interfering. We're just going to file it and let the chips fall where they may. But in other places, they might be perfectly okay with that. And you could actually help them in that decision. But you got to know what's going on in your jurisdiction. All right. So petitions, like other processes, can be, there can be variances and defects. These petitions are supposed to be filed timely within 15 days of somebody coming into the office. It's either supposed to be filed or there's a 15-day extension. Now, the law as it stands right now, if this is not done, it's not going to be thrown out as a matter of course. But something you may want to consider is that if a lot of time has passed and it seems unreasonable, ask the court to move to dismiss it, because so much time has elapsed. Maybe your client doesn't remember what happened, or maybe you can't track down the witnesses, or maybe it impacts the case in some other way. So just because it's not like a per se dismissal of the offense, don't be afraid to challenge it. Another theme of this discussion is be creative. And don't knock it until you've tried it, because it may work. I think everybody on this call has done that before. So as I mentioned, some fatal defects. It's got to be signed and verified by the chief court counselor, or it's not an official document. It'll be thrown out. Oh, the complainant. I'm sorry, I jumped. So, like, if it's law enforcement, if it's the member of the public, they have to sign it. Juvenile court counselor has to sign it, or the chief. And yes, the petition works like an indictment, so that it has to give sufficient notice to the youth charged of what they were charged with, what are the elements of the offenses. This can become definitely an issue of contention when something is incomplete or has the wrong elements. So make sure to take a look at it. Oh, and before I jump about the signed and approved for filing by a juvenile court counselor, just a couple of weeks ago, I was in another county, and a defender who had not identified this at adjudication still brought a motion to dismiss at disposition and was successful, because basically the court didn't have jurisdiction. So in case you think, these things don't really work, they do. Okay, and courts will definitely consider it. These are the main cases you need to know about the petitions. First case good, so first case bad, second case good. That's all I got. I'm still on summons, right, Berja?
Yep.
Okay. So, like criminal process, the child and the parent or guardian have to be notified in writing of when court is. The summons generally also serves as notice as to who the defender is, public defender, privately assigned counsel, contractor. It's got to be served. So if your client doesn't show up to court, don't just throw up your hands and say, I don't know, Your Honor, I don't know where my client is. Well, Mr. Zagrai, has your client been served? Oh, why didn't I think of that? If they haven't been served, they're going to continue the case, okay? They cannot pick up your kid on secure custody. And it's got to be on both. We hear this all the time that, like, oh, the parents were served, so everybody knew what was going on. No, the parent is not the client, okay? And we argue all the time. Berger was talking about Galt earlier, that service is notice, right? Service is the articulation of the constitutional theory of notice, the constitutional protection of notice. So if they ain't served, they don't have notice, and that's a constitutional violation as well as a statutory one. You heard it straight from Eric. All right. It's got to be done at least 5 days before the hearing. If your client shows up to court and says, "Here I am, Your Honor," okay, that's called a waiver. Oh, and now I will turn it back over to Berger.
All right, let me find the button. There's that button. Got this one. Okay, so secure custody. Again, this is one of those things that it's spelled out pretty clearly in the statute, and this is an area where we can get pretty darn argumentative. Some judges take these arguments a little bit better than others. It's a very technical part of the code. 1903 sets out very, very specifically the criteria for which, under which a child can be, held behind bars. Again, with the terminology, a lot of times I'll remind my judges that these kids are being held behind bars and solitary and all these ugly words, because secure custody is starting to sound a little too pretty nowadays. Let's see if I can get the clicking to work again. There we go. One of the requirements is that an initial hearing must happen within 5 days of taking the child into custody. And then reviews have to be held at intervals of either 10 or 30 days. And that kind of depends, again, on the age of the child, the offense, and if there's any waiver of any timelines. So I put a big old red graphic in here with the attorney's face, red, because I turn red in the face when I argue in front of a judge about whether or not a child should be held in custody based on the criteria. One of the things that we do is we go around and we watch court in different jurisdictions. And there's 100 counties, 100 ways, 100 different ways to do it. But I've seen several illegal ways of doing it. Substance use is not a basis for holding a child in custody. It's just not. The most common one is either charged with a felony and dangerous. And then there's some others, but again, it's very, very specific in the statute, the reasons you are allowed to hold a child in custody. When you're having your hearing and asking the judge to please release the child from custody, it's actually, while it feels like you're asking the judge to release the child, it's actually the state's burden to prove that this child should be in secure custody by clear and convincing evidence. So that's that sad part, I guess, for us. It's a pretty low standard at clear and convincing evidence, but the state does have to prove a reasonable factual basis for the charges themselves. So for the offense, reasonable factual basis is not defined anywhere, and it is whatever the judge wants it to be. And that is probably the lowest standard I have encountered in my years of practice. Reasonable factual basis being, can you articulate words into a full sentence? I think that's kind of how I would interpret it. The state also has to prove, though, that even if there is a reasonable factual basis, that there's no less intrusive alternative for this child other than to keep them behind bars. So this is a good area in which, I'll mention that you should know your jurisdiction and the resources available. I was in Western North Carolina before coming here to Wake County, and in Western North Carolina, there was custody and then there was the parent's house. Those were the options. There are a lot more options here in Wake County, for example, because there's more resources. Electronic monitoring, whenever that's available, is often heavily used by judges across the state. And you know, there's a section of the code that even talks about the sort of some of the options and the reasoning. So these are the state's burden, however, and the code does say that to establish that reasonable factual basis, they are supposed to put on evidence. So be familiar with this section. There are some cool little technical pieces that if you have a prosecutor that's either less familiar or you're traveling to a district that maybe the defenders have forgotten that section, you can remind your judge, this is the state's burden and they have to show these things for you to have the grounds to hold this child in custody. The secure custody order does have to be in writing, and it does have to have appropriate findings of fact. And then as part of this secure custody notion, we shackle our children here in North Carolina. We like to put cuffs on their ankles and wrists and drag them around and parade them. And we do have a specific statute, 7B 2402, that says, you know, that only happens if it has to happen. So you should be having shackling hearings unless your court counselor says we're not asking to have the restraints on. Then you should be having a restraints hearing in front of the judge before you even bring that child into a courtroom, where the judge has to decide that, you know, again, according to statutory criteria, that this child needs to remain in shackles. And then, of course, for secure custody, know your requirements for how often your review hearings are supposed to be happening. It can often be a point of strategy, whether I wouldn't say waive, but there are strategic decisions that can help your situation, especially with this. But it's the child's right to have this review of their secure custody status. And this goes back to the fact that, number one, they don't get a bond or bail set. It's in or out at the judge's discretion. And then number two, the fact that each time the judge must determine that this is the least intrusive alternative for the circumstances, that there's no other place that we can have this child that will accomplish the things that the secure custody is trying to accomplish. All right, so once you do that, once you get through any secure custody hearings, one of the next stages is first appearance. First appearance is required for felony allegations. Some districts will do a first appearance on misdemeanors. That's neither required nor, borderline appropriate, but they are required for felony allegations, and they do have to occur within 10 days of the filing of the petition. That comes back to your service issue, and can only be continued for good cause if the child's not in custody. There are timelines for probable cause that are associated with first appearance, so be familiar with those connections. And we'll talk about probable cause here in a little bit, but first appearance, it's the same. The judge is, as in adult court, the judge is saying to the child, this is your attorney, which they already have on the summons, but if they're making sure that they have contact information and that an attorney is appointed, if not retained, and advising them of their charges. They're also, there we go, I was getting ahead of myself too. Advising them of their charges, they're setting that PC hearing date, making sure they know who their attorney is, and they're also informing the parent that the parent, while the case is in juvenile court, is under the jurisdiction of the court. This is something to keep in mind. One of the things that the judge often orders of a parent is to make sure your child shows up in court. And when you have a 13, 14, 15-year-old who doesn't drive and they rely on their parent, I've seen it where neither the parent nor the child is there, and the defender doesn't really have much that they can offer. But at a minimum, you can say, well, if the parent's not here, how was the child going to get here? Let's not put this on the child. Let's not issue a secure custody order for a child whose parent isn't here. So remember that parents are also under the jurisdiction of the court. Okay, your probable cause hearing for all felonies, not all felonies, I'm sorry. for felonies for children that are 13 to 17 years old. Okay, younger than that, totally separate. Oop, I skipped ahead. Let me go back. Well, no, okay, just look at the screen. Just don't read that second part yet. But so you get a probable cause hearing for felonies for children 13 through 17 years old, unless the prosecutor goes ahead and gets an indictment. They can get an indictment for 16 or 17-year-olds that are charged with A through G felonies, or 13 through 15-year-olds with Class A felonies. That probable cause hearing must happen, and here's where it gets interesting, especially with the most recent statutory legislative updates, but within 15 days of the first appearance, right? That is a very short turnaround time. That's reflecting the speed and swift, effective disposition, the purpose of juvenile court. So the statute does allow, with raise the age, for that period to be extended to 90 days, only for children that are 16 or 17 years old that are charged with a Class A through G felony. So that means that the children that are 13, 14, and 15 years old and charged with a Class A felony, if you are trying to, if it's one of those situations where you don't need an indictment to come down, you actually, unless the state can make that indictment come down within 15 days, you've got a little bit on the upper hand there with the probable cause hearing still being set, at least for now, till they figure it out, within 15 days of the first appearance. And there is a provision in the statute that this time requirement can potentially be waived. I'm sorry, I said that wrong. The word waiver applies differently in the statute, but procedurally, you can waive that 15 days if for some reason that strategically works out better for you. And there are many times that it does. And if you want to talk more about it, that's what we're here for. The probable cause hearing must be by non-hearsay evidence or evidence that is an exception to the hearsay rules. So there's, Terry actually did a great blog post about this, but this seems to trip prosecutors up for some reason. It's non-hearsay evidence for probable cause hearings. And if the state, or as we were talking about this morning, the judge, for whatever reason, decides that this case is going to be transferred and it's what's called a discretionary transfer, where it's not mandatory, but the judge is going to hear, to have a hearing and decide, that requires 5 days notice prior to the PC hearing to be able to do that. If you've had your probable cause hearing and the judge finds there is no PC on that felony charge, then the judge will either dismiss it, or the judge may proceed if they find that there was a lesser included charge that they found there was probable cause on. They would go on to adjudication at that point. It does need to be a separate hearing for adjudication. When you're doing your probable cause hearing, remember that the discovery rules are a little bit different in juvenile court. 7B 2300 allows you to have discovery before your probable cause hearing. So you can take a different approach to those PC hearings in juvenile court because you should have access to your discovery. It also means that if you've asked for your discovery through your motion and you've not received it, you could ask if that information not be allowed in at the PC hearing. I've heard some jurisdictions interpret this a little bit differently, but I think the majority of them will say, yep, motion to suppress or motion, different, we'll talk about those, but state you had an obligation to turn over discovery, you did not, this is not coming in at the PC stage. Okay, so you've made it through your probable cause hearing. We're talking about potentially transferring the serious charges. So misdemeanors cannot be transferred to adult court into superior court unless it's a joinable offense with something that can be. Any child under the age of 13 years old, under no circumstances can they ever be transferred to adult court, even murders. There is a requirement of that proper notice of their intent to transfer. And this is kind of a chart that shows the combination of the child's age and what they're charged with, and whether it falls under what's called a mandatory transfer where the judge simply says, okay, I found PC, you must go to adult court, or discretionary transfer, which is where the judge then looks at the statutory factors and whether or not this child should be sent to adult court and be prosecuted as an adult. You'll notice that 13, 14, or 15-year-olds, for example, class B1 felonies, like just everything except for A's, that is a discretionary transfer. So think about that along with the fact that if you were to have a PC hearing and the judge finds not PC on something, but they do find a PC on a lesser included, we're already talking about the difference between a mandatory transfer and a discretionary transfer. Let me give you a little bit more specific of an example. First degree murder versus, like attempted or anything besides that first degree murder, right? That for a 13, 14, or 15-year-old can make the difference between mandatory transfer into adult court versus the judge now has to go through all of the factors listed in the transfer statute, determine whether this child should be treated as an adult, and has the opportunity to say, no, this case stays here. So, a 13-year-old that's originally charged with first degree murder doesn't necessarily have to go up if the judge doesn't find PC on that first degree murder. So that's sort of why we want to pay attention right from the very beginning. And of course, you see asterisks. The statute does allow the prosecutor to decline to transfer class D through G felonies for 16 and 17-year-olds. And then remember that there is a concept of reverse waiver that allows even cases that have been transferred with consent of both parties to come back into juvenile court. Boss, I may have you take over just simply because I'm about to lose my voice here. Are you comfortable with that?
I am. I have to stick control.
I will press the button.
And there I go. Right. Got here. So a little bit about some strategy. I know we're a little bit behind, so I'll try to run through kind of quickly. First thing, if you've got a mandatory transfer scheme, consider challenging the constitutionality. We've got all kinds of stuff on that. Just check with us or on our website. There's things to consider, but it might be a possibility. We've had defenders contact us about it. Not anything successful yet, but I think some judges consider it. If you're going to do a discretionary transfer hearing, don't wait until the end of the probable cause hearing to start thinking about it. Either make sure it's separate or be prepared to do it after PC, one or the other. But it can take months to gather the information, get your witnesses together, and build a case. It's just like building a case at sentencing. Consider hiring experts. I think at the transfer stage, not so much an investigator, but definitely a psychological expert or maybe even mitigation. And just like anywhere else, you can request funding through the court. Always get releases from the child and the parent for mental health records, educational records, DSS records, placement records, anything that you can get that can shed light on what your client has been through and what they might be amenable to. Remember, you can always get the entire DJJ file, and there's a link for that. Just let us know. And, make sure, like Berger was saying, you got to control these factors. There's not a catch-all factor, okay? There's not something that says at the end of the 8 factors and anything else the court wishes to consider. And another thing that happens all the time, the court's consideration is, well, everybody else was transferred. Okay, and I've seen that in orders. That is not a factor. That is not a factor. That's abuse of discretion, folks. All right. Whoops, I went too fast yet again. So we are moving from the pre-adjudication stage to adjudication, so I'll talk about that. Just like in district, but especially superior court, you can file pre-adjudication motions. You can do this in writing or orally, just depending. There's only really statutory information on suppression. We encourage doing it in writing and doing it ahead of time. Could be a flat out motion to dismiss, no jurisdiction, fatal variance in the statute, in the petition, whatever it is. Don't be afraid to start off your case with this needs to get thrown out. Motion to suppress, we'll talk about in a minute, but the number one evidence against our client is what, everybody? Our client. That's right, because they are likely to have said something to somebody about something. And that hits the suppress card. Challenge capacity. All of our clients, as they start out, are under 18. Do they really understand the process? Do they understand your role? Consider challenging it. There's a lot of experts out there who do a good job at this. And a plug for the future, we are supposed to have new capacity legislation implemented in 2025. Stay tuned for a webinar near you about that. All right, motions in limine. If there's certain information that the DA or DJJ is trying to bring out and you don't think it's legal, ask the judge to keep it out, to strike it. Maybe have an in-camera motion and hearing to determine what can be allowed to be heard by all the parties. You might want to move to close the courtroom, depending on the sensitivity of the case. And this is another one that's not used very often, but is very effective. Motion to sequester witnesses. You see all the time, if you've got a youth, especially a young child who's the alleged victim, and their parent is there. We've seen everything from, the judge says, yeah, that the parent doesn't need to be there, to correct me if I'm wrong, but like the child's so young, the parent is holding the child in the box. Okay, that to me seems a little bit like, well, they may be getting some clues from their parental unit there. See if you can sequester these witnesses. All right, suppression. Again, number one evidence, our client. We now have a statutory process for this. This came sort of in the shadow of JDB versus North Carolina. But it's important. This is not any different, I don't think, than you would file in adult criminal court. I know it's a little weird. You're in district court and you're like, what, I'm filing written motions in district court? Yes, because we're kind of a mishmash of both superior court kind of procedural practice but you're in front of a district court judge. But really consider filing those in writing. They can be made orally, but to just do it in writing. And then know how it works, right? If it's raised properly, now the state's got to show that it's admissible. That's not your job to show that it's inadmissible. It's the state's job to show that it's admissible. There is very specific law about custody and what can be, what is a situation under which a youth is in custody and information can be admitted. Not only in the statute, there was a case a couple of years ago. Is it DLH or DHL? DLH, is that right? Okay, everybody's like, yeah, maybe. There's a great case out of Wake County. Just contact us if you need it, where they run through specifically what should be considered in this. It was a school setting. A lot of our cases are school-based, not all of them, but it's a great rubric to look at how you determine this. And I would seriously consider it. Terry says DAH. We'll go with that. And as I mentioned, school searches get special rules. Remember, some 40% of all our offenses come from school, and your client's going to say something to the SRO, school resource officer, or the principal when the SRO is standing there. Just be aware of this. Berja, I'm going to keep talking until you tell me not to.
Works for me.
Here we go. All right, adjudication. Remember, this means trial, right? Okay, folks, the standard of proof is beyond a reasonable doubt. This applies to felonies and misdemeanors. There's no picking and choosing here. It doesn't matter what you're charged with, beyond a reasonable doubt. Remember, one of the rights we don't have is a trial, is right to jury trial. And by the way, you can't appeal any of these decisions to Superior Court. That is also missing from adult criminal court practice. Like you have the misdemeanor rule, you can appeal it, not here. The rules of evidence do apply. If you're not familiar with those, familiarize yourself. There's not any specific juvenile rules of evidence. I don't think I just said that out loud, didn't I? All right. You can admit, I mentioned before, there's a special AOC form. It's a little complex. We've tried to make it as youth-friendly as possible. But if you're going to admit, take the time, go through every question, because the judge is going to ask every single one of those questions. And it's nerve-wracking for your client to be standing up there and be asked these questions twice, because they're a little bit difficult to comprehend. So take your time and go over them. That's what the transcript is. And remember, the state is supposed to give a factual basis. It's not just what's on the petition. Now you can waive, formal reading and all that, but the state has to provide some evidence. And I just was thinking of a situation where I don't know if this is a Court of Appeals case or something, or I saw this in court where the court's going to make the DA do something, and if not, they're going to dismiss it. They're going to say that's not an. I think I've seen that once or twice where you've already admitted, the state gives their evidence, and the judge says that's not sufficient. So, that probably should have been an adjudicatory hearing, but that kind of thing does happen. Also, if your client is going to admit or they're going to testify, it is the duty of the court to tell them they still have the protection against self-incrimination. It's okay to stop the proceedings and say, Your Honor, could you please advise my client on their rights against self-incrimination? That is an appealable issue, and it doesn't hurt for your client to hear that more than once. Because why? Because the best evidence against your client is your client. We should have called the training that. I'm still talking. Here I go. Okay, disposition. This is what I was supposed to do anyway. Okay, this kind of looks familiar to you, but maybe not really. This is the chart that we use, similar to the adult sentencing chart. It's much smaller. Only 9 boxes. Get to know this. This is critical. You might think, oh, well, it's easy. It's like 1, 2, 3, low, medium, high, violent, serious, minor. How complicated could it be? Very complicated. There are, again, specific rules in the statute, especially when you're in like the 1, 2, 2, 3s boxes. These can be very tricky. But check out the statutes. I don't think well, you talked about it you talked about it last week at disposition. That's a good CLE to watch, or we have other resources. But if you ever have a question about, what's my client's history, what's their delinquency history level, we'd be glad to help. Okay, I'm not going through all of this, but you got to know it. You got to know this cold. If for no other reasons, because 4 points, right, gets you all the way to YDC. 4, that many. What is an adult criminal court? It's a lot more than that, like 19 or something. I forgot what it was, but it's a lot more. It takes a lot less delinquency history to get you placed in a YDC. We're supposed to be giving the youth a plan that suits them. I know I just showed you the chart and those boxes, but the actual disposition from the court should be tailored to your client's needs. Don't put up with 6 months on probation, 30 hours of community service, 5 days stayed in, the detention center, and write a letter of apology when your client is charged with, simple assault or armed robbery. Force the court into doing something that's relevant to your client. Why? Because if your client just gets a bunch of stuff to do, they are less likely to be successful and out of the system. Try to get the court to do that. This is, if you take anything away, take this away. Okay, not every kid has to be on probation. The court can order conditions of disposition without probation. The reason why probation is usually attached is because DJJ wants something hanging over their head, but probation is a part of disposition. It is not necessary to enter a disposition. In fact, the court can throw the whole thing out or continue it under conditions. Bring your own ideas to court. I know DJJ, if you've ever been in court, DJJ seems to be, in control of this. Bring your own thoughts, bring your own disposition report. Again, see last week's training on that. But just be aware, this is what I used to refer to as the kitchen sink hearing. Any and everything can come out. Make sure you know as much as you can. The last thing I want to say about disposition, the court counselor creates a report, try to get it before court. I know that might be wishful thinking in some places, but do what you can, because the report can be like that thick and then you're all sitting reading it and you don't even know what your client knows about it. Try to get it before court. All right. Let's see. Okay. Now, post disposition. This can mean a number of things. But first, what we're talking about, I know what I just said 2 minutes ago, probation, right? Because nearly every kid, even though we argue against it, nearly every kid gets it. Make sure you know what DJJ can ask for and what the court can order. It is not there is not a catch-all. It's got to be within those conditions in 2510. Probation violations are tricky. Make sure that your client has proper notice, and you should, if there's any indication that it wasn't a willful violation, consider contesting it. The court can do a number of things, including continuing the original conditions. They can modify or order a new disposition at a next higher level. Again, it seems easy, but you got to look at the details because they can't double you up on stuff. Know that you cannot be sent to YDC if it's a minor offense. Even if you violated probation, there's got to be at least 5. It's got to be on the 5th minor adjudication. That's a story for another day. But you cannot be, even if they have a felony in their past, if the probation is tied to a minor offense, they cannot be violated and go to YDC. Normally, it's 1 year with an extension for 1 year, but lately, sometimes, it can be 3 months, 6 months, 9 months, heck, it can be 11 months or 13 months. Just because this is the way we've always done it doesn't mean this is what's needed from your client. They may only have to do 30 hours of community service. That can be done in 3 or 4 months. And if they're not willing to just give you a shorter period of time, asking for it to end early. Set up a date in the future where you review it. Okay? It's that simple. A lot of what we're talking about today is like, here's the gold standard, dismissal, but if not dismissal, let's see if we can cut it back, cut it back, cut it back. Because the other thing I'm hoping we're taking away from this is that the longer your client stays in the system, the more likely they're going to end up in more serious situations like youth development centers. They've got to be in there for 6 months, and it's indefinite. It's very difficult for your client to understand, but they've basically got to work their way out of it. Don't worry about definite commitments, but if you have one, please call us because we never hear about it. Back in the jurisdictional chart, check to see their length of time in YDC. Every kid who goes to YDC gets out on 90 days PRS, okay? Sometimes this is an easy thing and sometimes it's not. If you have a chance, counsel your client on 90 days. Just do 90 days, because if not, guess what? You can get sent back. Okay. Most of the time, other parties file motions to get your client back in court, but you can make a motion to review it at any time. You can challenge the dispositional order without appealing it because it's in the best interest of your client, or it's illegal. And then I said, generally, the court counselor can initiate a review for violation. Once you get one of those, talk to the court counselor to see if it can be resolved any other way than coming to court. Because that's the best result. Try not to bring it back to court. Appeals, again, we've had whole separate trainings on appeals. Call us, call the office of the appellate defender if you have any questions, but the basics are these. If it's a transfer case, it's appealed to the Superior Court. Just know, though, it's abuse of discretion. It's very hard to overcome. And you've got 10 days. So if you're going to do it quickly. Now, they can do it whenever they feel like it, but you got to appeal it within 10 days. Okay. But to appeal a garden variety delinquency case, you got to wait till a final order, which is generally disposition. What does that mean? Well, you can't appeal a secure custody order. Okay, that's what makes our lives difficult. It's basically got to been a decision made by the court of some finality. It's done within 10 days. And release, if your client is in YDC or in some placement, or in other words, has their liberty removed from them, the only way they can stay pending appeal is if the court makes this finding, but you've got to ask the court. They're not going to make findings on their own, folks. You need to ask them. We could have an entire training on the 60-day rule. Basically, it's this. In some jurisdictions, they enter adjudication, but disposition is continued out for however long. If you don't want to lose a jurisdiction over the appeal of the adjudication, on day 61, you appeal that disposition without adjudication if disposition isn't entered. All right, we're going to wrap up super quick. There are a lot of resources out there for you. Thing number one, get one of these, juvenile code, okay? Sometimes our office has them and sometimes they don't. The 2023 edition should be coming out early next year. There's a lot of new laws. Please considering purchase one of them. No, I do not work for LexisNexis, but this is annotated. I can't see my face. This is annotated. Unlike, you can check these out online, the statutes, but these have the cases. Check it out. All right. This is us. You see most of us here. Hey, how's it going? Contact any of us for any questions. We do consultations all the time. No question is too short, too small. The Juvenile Defender Manual is now, it's got a little age on it, but a lot of the basics, especially like the strategy pieces, are in there. I encourage you to check it out. It's online for free. There's a lot of resources on the IDS website, mostly kind of administrative and technical, but there's also some substantive stuff, forensic resources and other things. There is a national organization called the Galt Center that provides training and resources and support of defenders. Especially if you've got a really quirky issue, you should contact them, or we'll be glad to introduce you to them. And then TJJ, the administration of the court counselors that's statewide, they've got some great resources. They put together different data and statistics. You can look at your individual county to see kind of what's going on, and that might help in your advocacy. They put out an annual report, which is chock full of great information about trends. And then they have, within that, they've got great graphics and snapshots. It's not just for data nerds, it's for everybody. Please consider taking a look at it. And they have different reports. And as you'll see on the last one, the school justice dashboard, again, not a lot of time to discuss this. This tells you by county and district the demographics of kids who are being referred from school to juvenile court. Those links are right there. They also do a lot of work on racial and ethnic disparities. Again, I'm sorry we don't have enough time to talk about this, but we know this is a major underlying factor in the work that we do, so please check that out. And I am done. Do I get a bonus for doing the rest of this, Berja? No.
Yes.
I know we've talked about a lot. Any questions, any thoughts? We are recording this. Tell your friends and neighbors. This will be online maybe by the end of the year, early next year. But thank you so much. Thank you, Berja. And I think that's all we got. Thanks, everybody.
For joining.